Chester Borrows.
Thank you, Mr Speaker, and I'm pleased to be able to take a short call in this third reading of the Criminal Procedure Reform and Modernisation Bill, a bill that has been a long time in coming to the House and 10 years in its construction. 10 years, or 7 of those 10 years, of course, being under the guidance of the previous Speaker's party. And I think it's pertinent to point that out because there seems to be in the tenor of what he said some residual thoughts that those 7 years were wasted. And I would tend to think that that isn't the case. And while the previous Speaker indicated that we'll be back in the House tweaking the criminal law over the next few years, that has always been the case, rightly or wrongly. But I don't believe for a moment that Minister Simon Power has been sitting on his hands or is resulting to or responding with knee-jerk reactions to matters that are only recently coming to the notice of the Parliament. This particular piece of legislation seeks to right for situations that have needed some dealing to for some time. Excessive delay, for example, the median time to dispose of a High Court jury trial is around 16 months, an increase of approximately 5 months in the last 5 years. And anybody who has been working within the justice sector who has been awake will have seen that this has become progressively worse over that time and has been entirely foreseeable. And although there have been some steps taken, it is time to do something to speed up that process. Excessive complexity. For example, the main laws for criminal procedure, the Summary Proceedings Act 1957 and Parts 12 and 13 of the Crimes Act 61, have been amended numerous times over 50 years, resulting in what has been described as an impenetrable maze for most non-lawyers. And that impenetrable maze has existed over a long period of time, a period of time when the previous Speaker was in government and was not without some influence within that government. The outdated legislative framework. For example, the current provisions were drafted on the assumption of a paper-based system, creating barriers to the use of modern technology. And it's been a sad thing to sit and watch that the use of modern technology as far as filing procedures and the monitoring of proceedings goes has actually been lagging behind significantly over last years, but bearing in mind the extent to which parties bringing proceedings to court rely on information technology in the preparation of those cases and those matters. And finally, it seeks to deal with excessive cost. For example, it's estimated that there are approximately 43,000 unnecessary court appearances a year in the criminal jurisdiction, and more than 2/3 of cases that reach a defendant hearing fail to proceed on the day. I do agree with the previous Speaker that there are a number of things that need fixing within the system, and there are some things that need fixing within the judicial system that are not accounted for within this bill. I do certainly agree that the wider concerns of the criminal justice system in this country extend beyond criminal procedure and into what are the drivers of crime. But I note that it was only this minister that even attempted to address the drivers of crime as an issue and as a cross-portfolio response to what brings people before the court and fail in the area of health, welfare, education and law and order. So I am pleased to support this bill, and I commend it to the House, noting the broad support that the bill does have across the chamber, and look forward to its passage into our law in the very near future. Thank you.